One federal judge just did something that nobody in Washington saw coming. He didn't tweak a law, he didn't adjust a fee. He looked at the entire permit system that Americans have lived under for generations and declared the whole thing unconstitutional. And what happened next is about to change everything you thought you knew about your rights. Here's what makes this story absolutely wild. This entire chain reaction didn't start with the Supreme Court. It didn't begin with some high-profile politician making headlines. It started with a single federal judge sitting in a courtroom that most people have never even heard of. He examined a permit system that everyone assumed was completely untouchable, and he made a decision that sent shockwaves through the entire legal system. Most judges play it safe. They trim a few lines here, adjust a fee there, make small changes that don't rock the boat. But this judge went straight for the jugular. He ripped the whole structure wide open and declared that the very concept of asking the government for permission to exercise a constitutional right is fundamentally unconstitutional. That single ruling tells you everything you need to know about just how broken the system looked from where he was sitting. But here's the part that should concern you. The government is already planning their counter move to this ruling, and what they have in store is something most people aren't prepared for. So stick with me because we're breaking down exactly what the death of the permit system means and the secret backup plan that certain states are about to launch the moment they think nobody's watching. Let's go back to the exact moment the ink dried on that order and trace how the chaos unfolded. This ruling didn't just target one specific fee. It didn't focus on one waiting period or one fingerprint requirement. It froze the entire permit structure in a single devastating move, calling it unconstitutional from top to bottom. The second that decision hit the public record, the legal landscape of America split right down the middle. Some courts looked at his reasoning and said he was absolutely right, that this is exactly what the Constitution demands. Others went into full panic mode, claiming he went way too far and endangered public safety. And just like that, overnight, your rights stopped depending on the Constitution and started depending entirely on which state border you happened to be standing behind. Now think about this from the Supreme Court's perspective. That kind of chaos is impossible to ignore. One judge didn't just create a legal disagreement. He kicked off a nationwide crisis that reached the highest court in the land faster than anyone could have predicted. But to truly understand why this judge made such a dramatic decision, you have to look at what he uncovered when he dug into the historical record. He wasn't searching for a headline. He wasn't trying to stir up controversy. He was simply trying to answer one basic question that nobody had seriously examined in a very long time. Did the early generations of this country ever require a permit to own or carry a firearm? The answer he found was so straightforward that even people who oppose firearms had a difficult time pretending it wasn't there.
Something happened that almost never happens in American law.
The Supreme Court just came down with its biggest Second Amendment ruling in more than a decade.
The bill allows gun owners 21 years and older to carry a weapon without a permit.
Either all constitutional rights are treated the same, or we don't have any rights. That's kind of how it goes.
The U.S. Supreme Court decision, which determined that concealed carry permit for gun owners was unconstitutional.
This notion that somehow deranged criminals will follow the law one way or the other, you can't get there.
It said in part that gun regulations must be consistent with the historical tradition of firearms regulations in the U.S.
There wasn't a single requirement in the founding era that said a person had to ask permission before carrying. Not one. Zero. People owned firearms the same way they owned tools, livestock, or Bibles. There were no applications to fill out, no waiting periods to endure, no government employee sitting behind a desk deciding whether you were responsible enough to exercise your rights. It was simply part of everyday life, completely unregulated and entirely unquestioned. But here's the part that made a lot of people extremely uncomfortable, and it's the part that most media coverage conveniently ignores. When the judge followed the timeline forward into the early 1900s, he discovered where the first permits actually came from. And the origin story is not what you've been told. These permits didn't appear because of legitimate public safety concerns. They didn't emerge in response to rising crime rates. They appeared because certain states wanted to decide who could own a firearm based on race, ethnicity, or social class.
First and foremost, basic gun safety does not have to be a threat to the Second Amendment.
I get people's concern. They think people should be required to get training in order to carry a firearm in public.
There's a myriad of things that can tie you up legally, financially, put you in jail, or maybe get you in very serious trouble with the police.
Saying setting a higher threshold in an emergency could mean life or death.
It's not what New Yorkers want, and we should have the right of determination of what we want to do in terms of our gun laws in our state.
the Department of Justice has formally declared a federal gun control law unconstitutional.
Southern states used these may-issue laws specifically to block recently freed Black Americans from arming themselves against violent groups that terrorize their communities. In northern cities like New York, the exact same tactics were aimed at Italian and Irish immigrants who were deemed undesirable by those in power. Once that truth went into the official ruling, everything changed. The judge wasn't just questioning modern laws anymore. He was exposing their deeply troubling origins. He stripped away the mask of safety and revealed what was really underneath, which was control.
High Court overturning New York's concealed carry law that requires gun holders to show a special need to be armed.
Half a dozen lawsuits were filed, and now, finally, here we are.
The permitless carry bill is certainly controversial, but what does it actually mean for Floridians?
What it does is it opens up the ability for people to be able to protect themselves to everyone.
If you carry, train, travel, or even maintain a firearm, this matters to you.
There is a difference between states deciding how they want to regulate any number of things versus stripping people of their rights to self-defense.
Now here's where things took a turn that genuinely caught me off guard. If you had asked me a year ago whether the federal government would jump into a permit case on the side of gun owners, I would have laughed at the suggestion. But that is exactly what happened, and it caught both sides completely unprepared. Instead of defending the bureaucracy like everyone expected, federal officials stepped forward and said something that shocked the legal world. They stated plainly that a right doesn't require permission. The moment they said that in clear, unambiguous language, the entire conversation shifted. They pointed out a simple piece of logic that most people overlook because we've become so accustomed to these restrictions. You don't fill out a form to speak at a political rally. You don't pay a fee to practice your faith or attend religious services. You don't wait weeks for a government background check before refusing a police search of your home. So why should the Second Amendment be treated like a request instead of a right? It was a devastating argument that completely dismantled the privilege mindset that has dominated this debate for decades.
The Supreme Court today handed down a major victory for gun control advocates.
Open carry has historically been regulated. The U.S. Supreme Court has said those types of regulations would be improper.
It's a constitutional right. It's not a privilege. So the ability to carry a firearm should be open to everyone.
One proposal allowing them to carry firearms without a license.
First of all, it's important that you know the gun and concealed carry laws in your home state and anywhere you plan to carry.
Unnecessary burdens making it more difficult or almost impossible for people to get and carry a firearm.
Then came the part that really grabbed my attention. They brought receipts, actual data from the 29 states that have already dropped permit requirements, the constitutional carry states. The real numbers showed that violent crime didn't rise the way critics had predicted. In some places, it actually dropped significantly. Whether someone supports or opposes this ruling, that is the kind of data you simply cannot brush aside. The message was crystal clear. The permit system wasn't built on safety or historical precedent. It was built on habit, power, and money.
People who want to carry weapons on them will no longer have to even apply for a license.
Those freedoms come with responsibility. And so you need to take it upon yourself and get the training and information when it comes to carrying a firearm.
It's not the gun owner, it's not the pistol permit holders, it's the criminals that are causing the violence and the gun problem.
21 years and older who are allowed to own a handgun will no longer need a license to carry it.
I don't think people should be required to have a permit to carry a gun if they are legally allowed to carry a firearm.
With gun control being implemented in a number of states, even where least expected, this is not a bill that gun owners should ignore.
This is the part that a lot of people misunderstand. And honestly, I completely get why. When you hear that the Supreme Court might erase every permit system in the country, your first reaction is probably relief. It feels like a massive weight finally lifting off your shoulders, like the battle has been won. But I wish the story were that simple. The truth is that states like California, New York, and New Jersey have been preparing for this exact moment for years. They are not getting ready to back down quietly. They are preparing to work around it entirely. They've figured out a frustratingly effective strategy.
We are making the intentional choice to increase gun access without any type of regulation.
To carry guns without concealed weapons licenses now cleared the State House.
Not having this Fourth Amendment to protect you and protect yourself,
That's pretty crazy.
This is something that actually comes from common law England. The king is sovereign, and the government has to waive that sovereign immunity.
If you're going to restrict a constitutional right, it has to be consistent with the nation's historical traditions of firearm regulation.
Erasing the permit doesn't stop them from creating something called a certification. If you can't stop the ruling itself, you shift the rules fast enough to make the victory feel completely meaningless. That's why certain states aren't panicking right now. They're actually smiling. They already know exactly what they're going to roll out the moment this ruling lands. The only reason the public hasn't heard about it yet is because the paperwork hasn't been officially announced. Let's look at New York, which has mastered what I call compliance theater. They've pulled this exact move before, rewriting laws just enough to avoid being the direct target of court action. They will likely remove the permit requirement entirely, but replace it with something called a character assessment process. They'll demand access to your social media accounts, interviews with your family members, and your complete medical history. California is preparing a different angle, one that sounds completely harmless until you actually read the fine print. They plan to replace the permit with a mandatory safety certification. It requires the exact same steps, the same costs, the same delays, and the same denials, just with a different name on the paperwork. The label changes, but the control stays exactly the same. New Jersey's approach is even more frustrating and bureaucratic. They're considering removing ownership permits entirely while quietly adding approval requirements for ammunition.
It's either a fund-generating scheme or it's designed to make it harder for people to carry firearms. That's it.
Aimed at declaring various federal gun restrictions unconstitutional in the state.
This case could reshape how far states can restrict your right to carry and where.
Public safety concerns must be addressed in ways that are lawful. This rule is not.
This means you can legally own the firearm, but you can't feed it without the state stepping in every single time you need to purchase rounds. It's essentially a soft prohibition designed to make the firearm a useless paperweight sitting in your safe. Illinois is exploring forced insurance policies. This is the poll tax strategy updated for the modern era. Price the insurance so high that working-class Americans are effectively locked out of exercising their rights. And Massachusetts is looking at training requirements so restricted that getting a slot in an approved class would feel like winning a lottery. Every single one of these moves tells the exact same story. The permit might disappear on paper, but the roadblock isn't going anywhere. The moment the Supreme Court releases its final decision, a lot of people are going to exhale with relief, but that is precisely where the real trouble begins. The second this ruling goes public, the states that oppose it won't shut down their permit systems politely. They will immediately start testing the edges, pushing the boundaries, and seeing exactly how much resistance they can get away with. If the past few years have taught us anything, it's that certain states are perfectly willing to drag their feet on compliance. They will stretch the definition of following the law until it barely resembles the ruling at all. You're going to see a massive split reaction across the country. Constitutional carry states will adjust quickly, treating the decision as confirmation that they were right all along. But the permit-heavy states will move slowly, act confused, and play ignorant. They will introduce new obstacles that look different on paper but function exactly like the old barriers did. The Supreme Court can knock down the structure, but it cannot stop states from rebuilding it overnight under a different name. That responsibility falls on citizens and legal organizations to file new lawsuits immediately, and that battle doesn't resolve quickly. It takes years to work through the courts.
Our citizens want gun safety, want firearm safety, want community safety.
Well, later today, a landmark civil rights case is set to be argued before the Supreme Court.
PF and the government is going to fight this every step of the way, and sooner or later it will land before the Supreme Court.
We won't see changes overnight, but it's going to be quick.
This decision isn't just reckless, it's reprehensible.
The danger doesn't hit when the Supreme Court announces the ruling. It hits in the days that follow when states start shifting their rules at a pace most people won't be ready for. I'm telling you this as someone who has watched these battles play out for years. The fastest way to get caught in a legal mess is to assume your state will handle this transition cleanly. Some will, but many absolutely won't. If you live in a constitutional carry state, you're in the safest position. The ruling will mostly strengthen what your state already practices. But even in friendly states, don't tune out because new requirements sometimes get slipped into unrelated bills when nobody's paying attention. If you're in a permit-heavy state, this is where things get complicated. Lawmakers there aren't waiting for guidance. They're actively working on countermeasures right now. They're calculating exactly how far they can push the boundaries of this ruling without getting dragged back into court. Trust me when I say they are willing to move fast and quiet if it keeps the old control structure alive. This is the time to keep your eyes open and follow local developments closely. Missing one small update right now could put you in a situation you never intended to find yourself in. That's it for today, folks. See you in the next video.